And this is who is assistant teaching these kids, the person in front of me today.
Morning, Your Honor. John Goldblatt, P 30758. Spool, please put your name.
All right, good morning. And today is the date scheduled for sentencing on your client's plea to operating while intoxicated. The high BAC and OWI with an occupant less than 16 were both dismissed by way of resolution between counsel at the pretrial. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we did, Your Honor. Your Honor, there is also a bond violation.
There is also a bond violation.
As to the bond violation, Your Honor, the bond violation is that she failed to appear on,
She tested positive for alcohol
Yes.
on December 15th, December 22nd. Well, hold on.
Excuse me, I didn't mean to cut the court off. She tested positive for alcohol and cocaine. And then on
December 3rd.
December 3rd, she failed to appear on the 15th, the 22nd, 2nd, and the 5th of January. As to the bond violation, she would plead guilty to that violation. Is that correct?
Yes.
I can't hear you, ma'am.
Yes.
Please raise your right hand. You solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes.
And you heard the allegations that were placed on the record, correct?
Yes.
As to those bond violations, how do you plead?
Guilty.
You've gone over your advice of rights regarding bond violation, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And you understand the possible penalty as a result of your plea. That this court could revoke your bond, this court could amend your bond, give you additional conditions, incarcerate you for a number of days or otherwise. Do you understand that's the array of of possible consequences?
I mean,
And knowing all of that, do you want to continue with your plea? Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? And counsel, if you can please vote to your client.
Thank you. Ms. Poole, you're on a bond to this court. Is that correct?
yes.
And
You need to speak up so we can record you, okay, please?
Yes.
And on December 3rd of 2025, did you, consume any alcohol?
Yes.
And that was in violation of that bond. Is that correct?
Yes.
And on that date, or just prior to that date, did you consume or use cocaine?
No.
Did you use marijuana?
Yes.
And marijuana was in violation of that as well. Is that correct?
Correct.
And did you obtain that marijuana from a friend or something? Is that correct?
Correct.
So you don't know what was in that marijuana, do you?
Yeah.
And you were supposed to test on the 15th, the 22nd, the 2nd, and the 5th. Is that correct?
Yeah.
And did you appear?
I did not.
Defense is satisfied, John.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violations. And counsel, there are 5 violations, 4 missed tests and
Right.
1
Oh,
positive.
Okay.
I'm taking, even though your client tested positive for alcohol and cocaine, I'm taking that as 1 violation because it's on 1 day.
Thank you, Your Honor. Your Honor, she's indicated to me that relapse as to the alcohol. She understands that she clearly is not supposed to be doing that in violation of the bond, particularly with respect to the charges. She denies the cocaine. However, she did indicate to me that she did smoke marijuana. That did not appear. So
Which calls into question whether or not your client really smoked marijuana or just used cocaine.
or used marijuana, which was painted. And that's why I raised that, because she didn't go to a dispensary to get it. This is what I'm indicating. As to the,
Actually, counsel did show marijuana in her system.
I didn't see that one. Oh, it does. You're right.
So really, it should say she tested positive for alcohol, cocaine, and marijuana.
And she's admitted to the marijuana as well as the alcohol. As to the mistakes, she was going through financial problems. She lost her car. Is that correct?
No, the train was And
I'm sorry?
can't use any issues and getting rides.
She understands that it's a violation and she had to take care of this, you know. We're asking the court to take all of that into consideration.
Did you communicate any of that with the court, ma'am?
I had called and I did leave a voicemail,
With who?
Ms. Shine,
Did you hear anything back?
no,
Did you email?
no,
Did you get a ride up here?
no, it was hard to get rides in general,
If you were to test right now, ma'am, what's in your system?
nothing.
Ma'am, you work with children. You're an assistant teacher. And this is who is assistant teaching these kids? The person in front of me today. And not only that, we're going to jump to the sentencing for a moment. You had your 4-year-old niece, nephew, in the vehicle with you. It's not even your child that you put in jeopardy. Somebody else's child, which if I recall correctly in reviewing the report, the parent of that child has passed, and then your dad has guardianship or custody of the child, correct?
Her sister's dead.
Your sister's dad. Okay. And so you had taken the child for the day or what have you, correct?
Yeah.
And this is what you did. You took the child with you to a friend's house. No? And it says that you stated you were at a friend's house in Lincoln Park and headed to the gas station. Quite a few mixed drinks.
I was at my friend's house prior to getting me my computer.
Oh, so you picked your nephew up while you were intoxicated.
I've been drinking for like, it was the summertime before we went back to work, and we were drinking for a few days, like up and down. And then the next day, I got my nephew taken to the dentist.
Pam, you are a 0.229. So you were drinking for a few days before school started. Were you on a 72-hour alcohol binge?
I wasn't like, it wasn't like nonstop, but we did drink a lot for those days.
Okay, and you didn't feel any differently when you went to pick up your nephew?
No,
Well, that's a problem. At a 0.229, you didn't feel any differently than you would have if you were a 0.00.
no,
Okay. And so if you were to test right now, ma'am, what's in your system? Not even marijuana? And you do not feel that you have a problem with alcohol? Okay. All right, counsel. Anything else you'd like this court to know?
With respect to the bond agreement or the sentencing as well?
Either one.
Well, we have reviewed the pre-sentence report. There were no additions, deletions, or corrections to be made. This pool has pled guilty to the violation of the bond violation. We're asking the recommendation be adopted.
Okay, with regards to the bond violation, this court's going to order 10 days jail.
Court consider suspending that?
No, I'm not considering suspending that. There's 5 violations. That's 2 days each violation. This court's also going to indicate after hearing from counsel reviewing the report, the recommendation that the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Poole and the legislative guidelines. This court's going to order 18 months of probation. You're eligible for early discharge, and I'll go over that shortly. You already have be on an alcohol tether for 45 days after you are released from jail. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. Do not use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for this condition is so that you can further, the court can monitor your progress and maintain abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you can have assistance in providing coping mechanisms so you can maintain sobriety, prevent relapse, hopefully preventing this matter from happening again. You are to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. The court's going to also order you to participate in fan meetings once per month. The rehabilitative goal for that condition is so you can have additional support to maintain sobriety as well as recovery resources. The court's going to order you to participate or to, for the workforce, 7 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life skills and give back to the community. The court's also going to order you not to have any unsupervised contact with your nephew. Any questions regarding those conditions? The court's going to order a $300 fine, $100 screening assessment fee, $900 supervision oversight fee, that's $50 a month at 18 months. And since you're eligible for early discharge, up to half of that will not be due. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, and workforce is $280. That's 7 days at $40 a day. And so that's a total of $2,005. You did post a bond, we'll apply your bond, and then you can set up a payment plan with probation upon your release. So you are to report to probation
Your Honor, would the court consider,
upon release.
with respect to the bond violation, rather than her appearing, being taken for sentencing, today, that she go to work for the rest of the week and then show up on Monday?
No, you're going today.
I'm doing my job and then I'm not gonna get one, I don't know how to pay all that.
Ma'am, your actions have put a number of people at risk. Your 4-year-old nephew, yourself, the community. You've indicated that you did not feel any different at a .229. You violated this court's order 5 different times. 5 different times. So you're going out this door today.
Your Honor,
Thank you. Have a good day.